Good evening, everybody. My name is Rod Escayola, and I'm a condominium lawyer with Gowling WLG. Welcome to our webinar, our weekly webinar. This is episode 4. This being episode 4, you know me by now. I've decided to title this one Rocky 4, which is the greatest fourth sequel in any Hollywood sequel. Now, for those who are joining us for the first time this week, what we've put together is an industry-wide crisis prevention cell. So we've gathered professionals from all walks of life and all sorts of professions to help the condominium industry navigate through these troubled waters. And that's what we've done now for 4 weeks, I guess. We've been at this for a month. I can't believe that. And week after week, we have these professionals that join us to give us practical knowledge and help us, as I said, navigate through these troubled times. So I'm going to introduce my cast of character. Many of them you'll recognize from prior episodes. Let's start with Sandy Folds, who will be speaking on behalf of CCI. Good evening, Sandy. Oh, people are muted. I wonder if, Graham, if you can unmute these people, because it's going to be a long evening if I'm the only one speaking.
Good afternoon.
Good. And then we have Catherine Gow speaking on behalf of ACMO. Good evening, Catherine.
Hi, everybody.
Denise Lash speaking on behalf of CAI, the Community Association Institute, and also the founder of Lash Condo Law. Good evening, Denise.
Hi, everyone.
And Graham McPherson from Gowling WLG.
Hi, everybody.
He's also the technician. David Plotkin from Gowlings as well. Good evening, David.
Good evening. I see I'm Rocky. How did I get that title?
Look at that, eh? It's the beard. And so David and Graham mainly are going to also monitor the chat channel. And finally, we have Jason Reed from the National Life Safety Group. Good evening, Jason.
Good evening, everyone.
Okay, so we have a full agenda tonight, and as we've done in the past, it's going to be a bit of a rapid fire exchange of information. We have received hundreds of questions, and I do mean hundreds of questions. And as a result of that, obviously, we will not be able to answer all the questions that were sent our way. We'll do our best. What we've done is we've tried to put together the most common questions to try to answer them, and we'll do our best to do that. But keep in mind, as I said, that we won't be able to answer every question. Now, my usual disclaimer, please keep in mind that whatever information we're providing tonight is Ontario-centric. When we refer to legislation, we're referring to Ontario legislation. That's where most of us are from, and that's where most of our attendees are from. Also keep in mind that the information we give you is sort of dated as of today, April 7th. The situation changes rapidly on a daily basis. And so for those of you who will watch this webinar later on Condo Advisor, keep in mind that the information is valid and accurate as of the date of this broadcast. Most importantly, I'd like to stress the fact that we are providing general information and may not apply to your situation. Your specific situation may require a different approach, a different protocol. It's crucially important that you all reach out to your advisors, be they lawyers, property managers, engineers, whoever is advising you, and get information that's applicable to your specific situation. And the last portion of my disclaimer, I have to advise everybody that this webinar is being recorded, and we try to upload it on the Condo Advisor blog, but it sort of takes us a while to get to that, and we apologize for that. We're trying our best to get to it, but it may take a couple of days to get there. Now, we have a chat channel. I see that people have discovered it already. Feel free to ask questions. We're going to do our best to answer some of these questions, but do focus on the discussion that we're having, because often we get a question that is about to come or that has just been covered, and you were too busy chatting with David and you didn't pay attention to the information when it was provided. Okay, now let's move on. The first thing we're going to do is we're going to tackle the issue of essential services in Ontario. And that's because last Saturday, as most of you know, the province has sort of focused and changed its essential services. And that threw everybody out for a loop, because we were trying to figure out, well, who's essential anymore, right? It was a bit of a popularity contest. You know, our lawyers essential, you know, our managers essential. And so now that we have the list of what is essential, I think what we need to do is we need to figure out exactly how does that affect the services that managers and contractors and engineers are providing to the industry. Are we now sort of prevented from providing you these services in light of this new list of essential services? So I'm going to turn to you, Graham. Maybe you can give us a bit of a, let's take a step back, and maybe you can sort of set the table. I mean, there's orders in councils, there's orders preventing us to gather, there's orders asking us to close businesses. Can you sort of clear this up a bit for us, Graham?
Yeah, definitely. So there are a lot of emergency orders floating around, and it can get confusing to nail down which ones are doing what. So I'll just kind of very quickly go over what the kind of main orders in place are now, and then we'll get more into what the differences in essential services are in a bit. But on that, so when it comes to essential services, what the order tells us is that anyone who is responsible for a place of business that has not been deemed as essential has to ensure that that place of business is closed. So what this tells us, because we sometimes get questions like, well, you know, what if, for example, our condominium were to ask somebody to come in and do some sort of work, and it turns out that that business wasn't essential? I mean, is the condominium now kind of on the hook for having invited them in? And on our reading of this order, it more appears that the onus is on the business person, the service, to restrict their own business. That said, I mean, you know, you certainly want to keep using your judgment on essential versus non-essential. And what we're also seeing with respect to businesses is that the order tells us that the person who is responsible for that place of business that's continuing to operate must ensure that it's doing so in accordance with all of the laws in place, and as well as all of the recommendations and instructions from public health officials. So if you are still an essential service like management, we have to make sure that you're following all of the recommendations and instructions from our public health officials. And then lastly, this one's kind of aside from business and more in terms of social gatherings. We all know that that there is a order in place right now preventing gatherings of 5 or more. And that 5 or more gathering applies to social events. So if you're an essential business and you have 6 people in the office and they all need to be there, as long as you are maintaining social distancing and employing all of the guidelines that public health tell us to employ, then you should be okay. That 5 people or less restriction applies to social gatherings.
Right, very useful. And I think it's important for everybody to ask themselves those questions with respect to the kind of services that are being provided and whether or not it is essential, because there are some pretty hefty fines associated with breaches to these orders in council. Were you going to cover that, Graham, or do I cover that? You're muted.
I can do that right now. Yeah, so you're right. The fines are aggressive, and so what the Emergency Act tells us is that anyone who fails to comply with an order or who interferes with someone who is exercising a duty under the order is guilty of an offense, and the fines and punishments are quite steep, or can be. For an individual, you can be fined up to $100,000 and a year in prison. If you're the director or officer of a company, that can be $500,000 and a year in prison. And for a corporation, it's a cool $10 million as a maximum. So
okay,
these
I was just going to say, and you can't use your reserve fund for that. I'm sorry, folks. Go on.
I mean,
Graham.
if you have a reserve fund that contemplates that, I mean, you're probably in good shape. But no, it cannot be used for those fines. So.
Okay, well, thanks so much. So now that we know what we can and can't do and how these directives apply, I guess I'd like maybe to turn to David. And David, maybe you can walk us through these changes to these essential services and how the definitions have changed last Saturday at 11:59 p.m. And maybe the first one that I'd be interested to hear you speak about is management and how that has been affected, if it has been affected by this new definition.
Thanks. Yes. So what this new essential services list has done is it has limited the numbers down. The previous list was about 74 or so. We're now down to in the 40s. And if you look at number 20 on that list, it groups maintenance, repair, and property management services together. And it's now, these roles are limited to strictly necessary to manage and maintain the safety, security, sanitation, and essential operation of institutional, commercial, industrial, and residential properties and buildings. So there, it is now the definition of what a property manager can do, what part of the roles of property management are quote unquote essential, are limited to those titles. And I know our managers are going to speak specifically about how this has, if it's changed, what they do on a daily basis at all. But that's the new definition for management.
Right. And so if it doesn't fall within something that's strictly necessary for the safety, security, and sanitation, or for the essential operations of the residential building, normally you wouldn't be able to do that because it's not an essential service. So Catherine, I'm going to turn to you. Has that now sort of cleared your plate? Is there all sorts of stuff that you can't do anymore because you're not essential?
So something that's happened in the past as a property manager, and I think most condominiums are already familiar with it, is as much and whenever we can do our work remotely, we are doing that. The problem is, or the thing is that there remain a good deal of tasks and responsibilities that cannot be done remotely. Some buildings are fortunate enough to have great systems where they can electronically identify and validate that some of the security patrols are taking place, that things like fob programming can take place off-site, that inspections of the property for safety and security purposes can take place, that instruction to staff can be validated. Notices, changes to how the condominium itself is going to function, what the expectations are for residences. That cannot all be done remotely. And so that does often necessitate attendance on site. That's the reality of it.
Right. What's interesting, I think, from what you're saying and what we discussed when we prepared for this, is that we sort of conclude, we're scratching our heads. Is there something that a property manager does that is not sort of strictly necessary to maintain the safety, security, sanitation, and essential operation of the building? And there aren't many things. I mean, everything you do, even the pics that you send out, even all of these notices, all of that is essential to the operations of the building. How does this definition, Sandy, how does this definition impact maybe what you'd expect your superintendent or concierge to do?
Well, your superintendent's duties really have not changed at all. They're doing everything that they've done in the past, including their safety and security inspections, cleaning if that's part of his or her duties, and actually more cleaning than ever before. Dealing with essential contractors, owners' issues, and of course, emergencies in your buildings as they arise. The only difference now is how your super is doing these duties. They need to take social distancing and personal health precautions into account all day long. This definitely slows down his or her day. You need to make sure your supers have all the supplies they need to do their job safely. It's most definitely not your super's duties to police the building, to enforce quarantine, isolation, or to break up social gatherings. We'll get into a bit more of that later.
Right. So we've done a list actually. You'll see the devil's in the details here. Jason from a National Life Safety Group. If I turn to you, and I'm going to ask you this. I mean, an important element of condo living involves security, be it parking control, access control, security guards. Is this new definition affecting in any way this kind of requirement?
No, I think the patrol's status will actually increase. I think what we're seeing is boards and property management organizations are taking a proactive role and saying, okay, we've got some of the load off the security guards or the concierge at the front desk, specifically with packages and escorts and access issues. But they're seeing an opportunity really to increase their virtual patrols. So the concierge or security may have access to an array of security cameras, and they're actually using those cameras to do a 360 view wherever they're covered, and then they're actually documenting that review. So where they can't leave due to manpower, they're actually at times increasing security. And I think that's vitally important for the simple reason is your eyes and ears used to be your residents. Your eyes and ears used to be your visitors and the vehicles coming in your parking garage. All of those should be reduced significantly right now. So the enhanced security will benefit the community. Parking control, concierge, and security are essential services, as you mentioned, Rod. I think the only other item I would think noteworthy in the security and concierge access or issue is access to the systems, operational continuity of CCTV systems, as well as logins, access control, even your front desk computer. We've got to start looking at third-party software logins. You know, typically we have the A game that works 8 to 4 at a lobby, and if that person doesn't show up one day, we may lose some of that access.
Right. And in fact, Jason, security is not only covered under maintenance, but it's also covered under item 6 of the list of essential services. And it's like pretty clear. I mean, security services for residences is an essential service. And so folks, as you've seen so far, I mean, pretty much if you have any of these staff or employees or contractors, they still are within the essential services as defined by the province. But what we're going to do now is we're going to dive into more contentious examples, and we're going to try to identify various other sort of routine tasks or work that needs to be done, and to see if at the end of the day, and the game today is this, to see if it falls within what's required, strictly required to maintain safety, security, sanitation, or the essential operations of the building. If it falls within that, it's got to continue. If it doesn't fall within that, I would caution the average condo corp out there, and I'd wonder whether or not we're entitled to expect it and demand it. Now, believe it or not, perhaps the most contentious of these tasks that people have on their minds right now is landscape, lawn care, cutting hedges, pruning trees. And so we had a raging debate over that, believe it or not. And so I'm going to turn to you, Sandy of Wilson Blanchard Management. I'm going to turn to you, and like, where did we land on this one? Is that an essential service?
Well, that's still a very good question. So Landscape Ontario has published on their website that Section 20 of the new essential workplaces list refers to maintenance, repair, and property management services strictly necessary to manage and maintain safety, security, sanitation, and essential operation of properties and buildings. We've all heard that. However, it notes that this section does not specifically describe horticultural activities. This is where our debate went on. They're currently lobbying the government for clear answers, but in the meantime, they are taking the position that member companies are urged to not work unless they can cite specific government permission, provide upgraded safety protocols, and have confirmed insurance coverage. So that is straight from Landscape Ontario's website. Now, the reality is many landscaping companies are determining that their weekly maintenance is essential service and have implemented safety protocols for their staff. Landscaping, as we know, is a huge priority for many condo corporations, especially townhouses. But is cutting the grass every week being done for aesthetic purposes, or is it a necessity for safety and security? Most definitely, parts of what our landscapers do on a weekly basis is extremely important and required. They clean the catch basins to make sure that they don't flood. They pick up litter. They trim bushes to ensure clear, safe paths. And they remove broken or low-hanging branches for resident safety. The true answer right now is we are just waiting for Landscape Ontario to obtain a clear mandate on this issue as quickly as possible, as this is our landscaping season. It's now starting.
Right. Well, I heard you mention security, and so that, of course, brings me maybe to ask Jason, what's your take on that? Is there an element of security behind this kind of work, landscaping work?
There is an element of it. Maintaining it was modeled after the broken window theory that was launched in the United States. And it's, you know, when you have a derelict building or a building that doesn't seem to be maintained, it seems to be more of a target for mischievous activity, if you will. So there's many studies that have identified that keeping your building maintained, such as cutting the grass, keeping trim limbs away from windows on ground floor units, keeping the trees trimmed allows the effective use of your exterior lighting and allows you to contribute to that crime prevention through environmental design. So there's a lot involved here, but I would also agree that, you know, I wouldn't constitute putting down mulch as a security kind of benefit.
Right, and so you see, that's the challenge that we have. We need to try to find, every time you'll ask yourself the question, I see on the chat people are asking all sorts of questions. If you don't cut the grass, it's going to be maybe more rodents, maybe more insects, and so on and so forth. But at the end of the day, you have to ask yourself, is that sort of an essential element to the operations of the building? And that's how you're going to be able to figure out once and for all whether or not it's covered. Let's switch topics. What about window washing? Is that essential to the operations of a building? Does anybody want to take this on? Maybe Sandy or Catherine?
I think we agreed, Sandy, that I would take this on, and it kind of leads from the last comment into this comment. Part of what our discussion, our debate last night turned into is, what are we doing and why are we doing it? And I think if we look at all of the services that we would typically provide, now is a different and a unique time. And I revert back to some advice that we provided to folks in previous webinars. We want to, first and foremost, try to be the voice of calm and rationality, and try to be consistent in our communications to homeowners. One of the things that I think is true is that everybody is saying as loudly as they can, using as many expletives as television will provide, that folks should stay at home. And it's not quite business as usual. And I'll also be the first to admit that cutting the grass today is probably not an emergency. And there may or may not be something that is different by way of an emergency later on. But the things that a condominium corporation needs to consider when they're looking at any of the work that's going to take place is, first and foremost, from a safety perspective. Can the work be done safely? How you're going to protect both the common elements from a safety perspective and the workers from a safety perspective. And some of the items in particular that are important have to do with sanitation. So the ability of people who are working being able to sanitize. And I make mention of this in reference to this because, for instance, when we are talking about townhomes and whether or not you would do something like landscaping at townhomes, they've never had the opportunity to sanitize at the townhouse complex. There aren't those facilities, but that was also easier done by crews in the past because they probably stopped off at the gas station, the Tim Hortons, the I don't know where to do that.
Sure. So window washing,
it's a bit of a debate.
Yeah, okay.
I know that people who are in their homes, safe at homes, would really love to have clean windows. And the question will be whether or not those window cleaning systems can be accessed without going through any resident space. So if you're in an exclusive use terrace area, if you're going through a resident's home in order to access those roof anchor devices, that's not possible, not at all. Today, do I think that window cleaning is not essential? Nothing is going to be damaged if you don't clean the windows. I do know it would make a significant difference to how people feel while they're safe at home.
Who's tackling garage cleaning then? Is that essential to either sanitation or essential operations of a building?
The component that I do think is terribly important, as Sandy mentioned previously, is cleaning of the catch basins and the pits. And that's typically done in connection with the underground garage wash. The second problem is where people will go. So most often we take advantage of the fact that people are away at work when we clean the garage, and that won't be possible. So I would recommend that we make sure that the building's catch basins are all cleaned, and in particular, because we're still doing spring cleanup, leaves and things like that. I think that's necessary. That'll help prevent backups, and that can be an even bigger problem. Jason made reference to floods and things of that nature, and we want to make sure that things can go away from the site safely. Those are very important things.
Okay, I'm going to go back to David now, switch topics, and maybe David, you can help us understand the definition of construction under this new list, because at the end of the day, there's a lot of work that's coming upon us. This is construction season. People have been waiting all winter to start fixing roofs and cladding and whatnot, and so where are we left with? Are you there, David?
David's not.
No, I see he's like sort of in slow motion. Are you there, Dave?
Yes, you're not able to hear me.
I hear you now.
You hear me now? Okay,
yeah.
perfect. All right. So we saw in the last essential services list that the construction industry had a whole number of bullet points, and it seemed to include almost every single construction worker that existed. I have a number of friends in the construction industry who were not thrilled about that. At this point, aside from what we saw before in the maintenance and repair, there's also under item number 30 in the new essential services list, residential construction projects where there's 3 items. A footing, oh, I see they're up on the screen here. So a footing permit has been granted for single family, semi-detached, and townhomes. An above grade structural permit has been granted for condominiums, mixed use, and other buildings. Or the project involves renovations to residential properties and construction work was started before April 4th, 2020. So that's the main changes that would affect condos here. Work that was already started prior to April 4th, and any above ground structural work for which a permit was granted as well.
Okay, very good. Graham, I think you had some stats from our latest condo advisor survey. Do you want to talk about these?
Yeah, absolutely. So in the latest survey, what we've seen in terms of delayed work is that 14% of our respondents have indicated that they have not delayed any work, which I guess leads us to extrapolate that 86% of our respondents have. The most popular response that we did receive for the delays was actually a complete tie between the garage pressure cleaning and capital work like cladding, roofing, caulking, and window replacements.
Okay, very good. And so I guess now what we're going to do is we're going to drill in. We're going to try to see how does that definition apply to all sorts of work. And Denise, I'm going to turn to you now. Denise from Lash Condo Law. How does this apply to common element work?
Yeah, well, it's quite interesting because here we see that the word essential is not really used. So as long as the work had been started before April the 4th, the work can continue. And corporations are trying to decide whether they should or they shouldn't continue. Of course, if they decide that they don't want to continue, they have to make sure that they deal with their agreements. Excuse me. And speak to the contractor. The contractors will then decide whether they should postpone or not. So that's the first step. But there may be other reasons where you don't want to leave unfinished work that could pose a health or safety risk. So, consider both factors in deciding whether to proceed or not. But ultimately, it's up to the corporation, if the work was started before April 4th, whether to proceed or not. I have received questions about phased work because, of course, there are corporations that had proceeded with a particular phase and now they're on to their second phase.
Right, and maybe let me just jump in. Let's give a
Sure.
real example here and we'll build on that because we're getting this quite a lot. So this is the example. There's a corporation that has a multi-phase sort of project. Let's say they're working on their waterproofing the building envelope and they worked on it all the way till October. Then they stopped for the winter. They put away all the scaffoldings and next week they were scheduled to start again. They were scheduled to mobilize again and put scaffolding up again and start working on the building envelope. And let's assume that there's some water infiltration, but it's not a deluge. It's a bit of water infiltration. So how do we deal with that? Has the work commenced before?
Yeah, well, there's a couple points there. I don't think that number 30, this was meant to apply to the phased approach. I think if you're looking at work that needs to be done, that it is more of a repair nature, then we're back to 20, which is it essential? And your example there, Rod, you said there was concerns, there could be flooding, there could be leaks. That would fall under this maintenance and that would deal with repairs. So you see it says maintenance and repairs.
Right.
So that would include that. So I don't think that a phased project would fall under the April 4th construction under number 30. But of course, you've got to get your own legal opinion to determine whether that is the case or not.
Right. Okay, and so maybe what I'll do now is I'll tackle the in-suite renovations. And this is another one that we often get quite often. And can owners be prevented from doing work in their units during this quarantine period, during this isolation period? Now, renovations in a unit, they can range from something that's significant, changing cabinetry, changing flooring, changing water appliances, gutting the place. It can go from that extreme to something far more superficial and aesthetic sort of driven, painting a unit, for instance. Now, what all of these have in common is that it increases traffic over the common elements. So you have contractors that have to come in and go out, sometimes with bulky equipment, sometimes with materials. Sometimes it requires that the superintendent be taken away from cleaning or other more essential duties to pad the elevator. And so you're basically increasing traffic that may not be necessary or essential. And so the question, of course, I understand that the unit owner wants that to move forward, but the rest of the community may be questioning whether or not that makes sense at this point in time to put energies and to increase the traffic there. So what we were saying so far to our clients was this. We were saying, well, a corporation under Section 17 of the Act, a corporation has a duty to control, manage, and administer the common elements. And to us, what that meant was, well, the corporation would be entitled to minimize or restrict or control to some extent the use being made of common elements, the kinds of people that will be able to go over common elements, the kind of equipment that will be allowed over common elements in the context of this crisis. Whether you have a rule about constructions or renovation or not, we find that the Act already provides that authority. Now, that was the theory. And this week we had a case, not ours, not our case, that shed some light on that. And so this is the story of someone who apparently, and the facts are there's not a lot of facts that we can go on, but I mean, from what we read on the case, the owner wanted to paint the unit and had a couple of contractors coming in and painting the units. Now, when she was told that she couldn't go ahead with this work, well, the answer was, well, they're my friends. In fact, they're not contractors. I'm just having friends over, right? And so this went to court. There were 2 hearings within a day, and it was on an urgent basis because obviously you need an answer right away. Now, things to keep in mind, the owner in question was self-represented. She did not have a lawyer. And another thing to keep in mind is that eventually they agreed to postpone the question to the month of June to allow this person to go get a lawyer. But what we get from this case is this, and I think it is very clear. Courts will hear these matters. Even though the courts are shut down to some extent, they have very reduced staff, very reduced in their operations. They will hear these kinds of questions where the issue is the safety and security and health of a condominium corporation. And so the judge was quite clear that the judge would rule on this with or without the owner present, actually. And the second thing that's interesting is that although it's on consent, the court did rule that this kind of work was suspended, at least until there was a fulsome argument on that basis. And so I think this reassures all of us that corporations have the authority to restrict or prevent or control the kind of work that will take place. Having said in units, having said that, to me, any work that's required has to be allowed to proceed. And I don't know, Denise, if you were going to sort of tackle how would you measure whether work is required in a unit? What kind of factors do you consider?
Yeah, well, I've had a couple of cases. I think if a unit owner has to move in and there's certain essential items that have to be completed, like the kitchen and the washroom, I think those should go ahead. And I have had situations where, and that I see that corporations aren't permitting it. And I just don't think that's the right approach. I think, if it's purely cosmetic, an owner can reside in there, then I understand that, but not if somebody has to reside in it. And that's the only way they can.
Right. And so there's going to be a lot of discretion needing to be exercised. And as David keeps repeating every time we conclude these seminars, you got to be reasonable, right? And so approach this in a reasonable manner. Is this work essential? Is this work required? Can this work wait? And if it can wait, and if it's not required to occupy the unit, I probably wouldn't allow it to go on. Okay, and so let me see here. I'm trying to get back to control the slides. There it is. David, back to you. What can you tell us about short-term rentals? Has the province finally killed short-term rentals in condos? Is that what happened?
Breaking news. It happened very recently in the past 24 hours, I believe. It hasn't killed short-term rentals, but it has very much limited short-term rentals, at least for the next 14 days, and then it's the renewable order thereafter, as they've been doing. So the exact wording of the, as you put up on the screen, is that every person who provides short-term rentals in rental accommodations shall ensure that any rentals booked after April 4th are only provided to individuals who are in need of housing during the emergency period. Now, as a lawyer, I would have loved if this was expressed in a little more of a clear way. Who is in need of housing? I'm sure there'll be a number of discussions that certain people will bring up. The general consensus, at least of what I've heard, is this is certainly supposed to apply to those on the front lines who are dealing with medical health professionals. If a doctor is working away from where they are, or they need to be away from their own family because of their being exposed on a regular basis, this is definitely what we feel is meant to be targeted by this. And as Graham had discussed earlier, the risk of an Airbnb owner playing games now and trying to say, oh, this person's really in need, that Airbnb owner is risking a $100,000 fine. So I don't think now is the time for Airbnb owners to be playing that game, and it's very easy to send them this instruction, being saying, like, you do this at your own risk. Our view of as a corporation, as our lawyers have advised us, is that short-term rentals are not allowed except for this very strict exception. Do so at your own risk, and the possibility of a fine to you is $100,000.
Right, and by fine, you're not talking about the corporation fining them, we're talking about the province fining them. I don't want anybody to get excited at home starting to fine people. I'm going to add something else though. While short-term rentals for people requiring housing during the emergency, while that is allowed at the provincial level, it doesn't mean that the corporation has to accommodate that. We've always taken the position that a corporation can be more restrictive than a higher level of government, but not more permissive. So the fact that the federal is allowing cannabis, the fact that the city is allowing an X number of pets or dogs, doesn't prevent a corporation from being more restrictive. What the corporation can't do is be more permissive, allowing something that a higher level has prohibited. So the fact that this exception does exist doesn't mean that you have to necessarily accommodate it within your condo corporation. We're going to switch topics entirely. We're going to now go on to the quarantine, because we're getting a lot of questions about quarantine, and the kinds of question we're getting is, well, so can a corporation impose quarantine? Can a corporation prevent visitors from attending the property? Can the corporation force the information from the owners to find out if an owner has been infected by the virus? And if we get that information, what can we do with it? So basically what we're hearing from a lot of people, from a lot of directors and from some manager is, basically, can the corporation act as a public health authority and the police at the same time? Now, you have to keep in mind, before I dive in, there's a significant difference between how the province is regulating businesses and closing maybe a storefront or something to that effect, or a commercial plaza, and how we deal with residential setting. It's a residential setting. We have people, they need to live, this is their home. In fact, they're being forced back to their home. So we can't turn this into Nazi land. We have to sort of keep in mind that we need to balance competing interests here. So let's first maybe turn to Catherine, who'll speak on behalf of ACMO here. Catherine, what kind of precautions? I know you went on the internet, you try to find how various cities are guiding corporations with how to deal with multi-residential setup. What did you find? What did you come up with?
And I'm most well versed in Toronto. It happens to be where I practice personally, of course. And I think Toronto might be a little bit different or unique. The mayor of Toronto has special emergency authorities. And so I was able to find, and I don't know if it forms part of the slide deck or not, but some very specific guidance to multi-residential with respect to what their expectations are for things like use of the elevator, for things like sanitation of common areas and elements on a regular basis, and also certain precautions that folks would take. And the reality of it as well is that this information changes and on a daily, almost hourly basis. So breaking news, the Easter Bunny and the Tooth Fairy are both designated essential, absolutely need to come into condo land. So I want to make sure that that's very clear. And I say that not being joking, I say that being very serious, because the other thing that I want to remind folks is that there are lots of people who live in our condominiums, and some of them are little people. And I'm concerned that the covenant of trust that we have when residents are advising us of people in their homes or in their families who are positive, we have to hold that information with the trust that it was given to us. And so it is essential so that we can protect people. I think we also have to make the positive assumption that people who are coming to the condominium, particularly through this holiday weekend, are doing so to not visit people, but to perhaps offer care and offer supplies. Jason had some really great points, which he's likely to expand upon as well. Posting that kind of information at the outside of the building or somewhere where it can be seen before people enter, reminding them that there are restrictions in place, that we all are to be physically distancing, that now is not the time to visit. It is the time to provide essential services only. I think it's very important. I'm also concerned about creating a situation where you have altercations with staff and enabling staff to take appropriate action and who will back them up. So that's important.
So let's deal with the question you threw at Jason. Jason, what kind of advice or guidance can you give us to help us keep peace, good order, and good government in a condo corporation, especially over the long weekend that's coming up?
I think with the upcoming festivities or lack of festivities that's going to happen in people's suites this weekend is going to be challenging. But I think what's very important for a condo corporation to implement is clear direction. So, for example, I would suggest posting something just at the front doors of the lobby that stated and explicitly echoed the public health and safety guidelines. For example, you are not permitted to enter this building unless if in the fact that you have traveled outside of the country in the last 14 days. I would make that statement right in bold in my letterhead, and I would post that. Why? Because I would post that as a clear, identification and a basic due diligence to protect my residents in my building. Because you know what? You could have service contractors, service providers, visitors, not necessarily know that or interpret that as of yet. I'd also have that notice that says, when you come into the building, please respect social distancing. Because public health has made this a guideline, we need to reinforce that at the entrances to our buildings. In fact, I even suggest you go a step further and post those on the elevator lobbies of every floor. I think it's important to be transparent and have the residents understand that when we talk about additional cleaning in a condominium, what does that mean? I would be hard pressed to see a condominium that is cleaning the elevator buttons on 27 floors more than twice a day. More than twice a day. So what that means is if you've got 30 residents on a floor or 100 residents on a floor, that's an awful lot of travel. And I think when you have that honesty, that accountability and transparency, that clear direction, but it's also allowing the residents to make that informed decision and say, wow, you know what, enhanced cleaning is good. My teams are increasing this, but there's limitations, and I think it needs to be clear.
Right. It allows people to take these decisions, because otherwise, if all we say is, we've increased our protocol, well, what does that mean exactly? Can I go and lick the elevator buttons, or do I need to wear gloves when I touch them, kind of thing?
Don't ever lick elevator buttons. No. All joking aside, my best advice to everybody is to assume that the last surface you touched was last touched by somebody who is COVID positive. And I think that that is a reasonable assumption at this point in time. If you look at what all public health outlets are telling you, is they're concerned about community transmission. And that's not just about the condo you live in, that's about public transit, that's about why public areas for play are closed, it's why some trails are closed.
Sure. But let me just move along here, Catherine. I want to touch a topic that's to me very important. It's the question of visitors, and I'm sort of building on something that Jason said. And Jason said, we'll put a sign at the door that says, if you've traveled in the last 14 days, you can't come in. Well, there may be exceptions to that, and one of the obvious exceptions is if you live there and you're returning from travel. In fact, what you have to do is you have to go to your unit and you have to stay in your unit for 14 days. And you won't be able to fly to your unit. You'll need to sort of get to your unit. But even beyond that, if there's more than just the owner that lives in the unit. The owner may have a girlfriend or a boyfriend or a spouse, and the owner may have a parent, and the owner may have kids. And so now we're sort of venturing into the visitors question, I guess. And Catherine, were you going to be tackling that? How do we deal with visitors, and to what extent can we control that? And just so you know, then I'm going to ask the same question of Denise.
So to date, and those who know me better, and I'm becoming more comfortable with you all, the 600 or so plus attendees, and so I'm starting to treat you in the same way. I refer to it as a get out of jail free card. And so far, I haven't seen a get out of jail free card issued to a condominium corporation that says that people who do have homes don't still have some rights to have certain people come to see them. And I'm always concerned, as David would put it, in being reasonable in that regard. And I want to make sure that we are facilitating people who are coming to visit our residents, who are helping them to be cared for if they are ill, if they are elderly, and to sanitize their own premises. So I think that's important. I think we also have to assume that people are taking the appropriate precautions and try to protect against those who are not. The final thing is, if you do have concern that somebody is behaving inappropriately, I believe that the tap right now is either to one of the police lines or the snitch lines, which is what they're being called in certain jurisdictions. In Toronto, I know that 311 is a convenient, fast way of making a report. In trying to contact the non-emergency number for police, we have been referred back to public health, and I'm unaware of any other enforcement, for lack of a better way of putting it, that stems forward from there. And
Right.
If anybody does know of any, I'd love to hear about it.
And I think for all of you out there, you need to sort of Google your municipality, and various municipalities are tackling this a different way, just as Catherine was indicating. Hamilton, Ottawa have a snitch line. Well, of course, Ottawa would have a snitch line. Do you expect anything else? Some other cities don't have that. In some cities, they refer you to public health. In other cities, they refer you to the police, and in other cities, they refer you to the bylaw office, the municipal bylaw office. Before I said I would turn to Denise. So Denise, what about visitors? We're hearing all sorts of horror stories out there.
Well, I want to talk to this because, there's some concerning things. And I think we discussed this yesterday when this came to my attention. But at the moment, and I'm saying at the moment because things could change tomorrow, there is no legal authority to prevent visitors from entering the common elements. Unless there's a known risk, visitors are entitled to come into condominium corporations. And my position, and this is my position, and I hope that many of us agree with this, is that, the Condominium Act, there's section 17, and that is to control, manage, and administer the common elements. It doesn't go as far as preventing visitors from entering onto the property. And I think all the lawyers agree to that.
Oh, for sure.
Okay, good. And I know that there are some that have taken a different approach. And I don't know, Rod, do you have that signage, or did you put it up?
Oh, I don't think I did, no. Oh, there it is.
This one is something that I understand a corporation has done, and what it says is that Due to COVID-19, this building is closed and open to residents only. That's sort of worded a bit strangely. Real estate agents and visitors will not be permitted. You know, we have to rely on the health officials. I mean, even the government at all levels haven't restricted people from coming in and out of homes. And until they do, I don't see how a condominium corporation could go that far. And, you know, the situation that I had where that was brought to my attention was a tenant whose boyfriend moved in with her about a week ago. Then they posted this signage and they told her her boyfriend has to leave. Boyfriend was not a traveler. And what they did is they deactivated her fob. So now she cannot leave her unit or her boyfriend because she won't be able to come in unless her boyfriend leaves. I don't agree with that approach.
Yeah, that's it goes back to the corporation has the ability to control common elements, but there has to be a reasonableness to it all. And I mean, where does one go from occupant or resident to visitor? That's a very slippery slope. But you raised something, Denise. You talked about the sign indicating that realtors were not allowed in. Graham, can you maybe cover that? I think we skipped over that. What about open houses? How does the province deal with this?
Yeah, so as of April 4th, when the changes to essential services came out, the government also clarified its position on open houses, stating that everyone who is responsible for a business that provides real estate services must ensure that the business doesn't host, provide, or support any open house events. So similar to what I was saying before, I think the risk here is for the real estate services, if there is an open house, who would be on the hook for it. But, what we have to remember that what this means from the government is that open houses have been deemed to be no longer acceptable, but that doesn't mean that we can prevent people from selling. That doesn't mean we can automatically prevent real estate agents from listing. It is restricted to open houses and just that.
Okay, so we're going to do something fun right now, dear people at home. I'm going to try to see if it works. We're going to launch a poll because the next topic will deal with what do you do with confirmed cases. I'm going to launch a poll, and if you're on your computer or your tablet, your iPad or whatnot, you may be able to answer that. If it doesn't work, well, try better next time, I guess. So this is the poll. Do you have any positive COVID-19 cases in your condominium corporation? Graham, do you see it on the screen? Because I pressed it. Is it there?
It's not appearing for me. Did you launch it?
I did. No, that's not going to work, eh? You don't see it?
Oh.
Okay, well, we'll see if it pops up. But if it doesn't, then just raise your hand. David, if you could just maybe count the hands that are raised at people at home to see who has a confirmed case. So let's talk about confirmed cases and specifically, what do you tell owners when you do have a known case in your condo corporation? And we hear all sorts of questions. People are asking us, can we tape shut their doors? Can we put a sign on the door? Do we need to tell the floor above and the floor below, and so on and so forth? And I would say this. This is what we've recommended so far. If there's a known case within the community, for sure, we recommend that a letter be sent to the community, not identifying the individual in question, not identifying the unit, not even identifying the floor, but just indicating that there is a known case, and these are the precautions that we've taken so far, we as a corporation. We also take a second step, and we write a letter to the owner in question, and we sort of list what the expectations and the demands, and we link it to the various sort of statutory authority or regulations supporting our request and our ask of that person. That's what we do, and that's pretty much where we feel we can stop. Now, a lot of people have asked us, well, on what basis must you maintain the information private and confidential? Medical information is highly regulated and highly sensitive. There's all sorts of legislation that supports that. Personal Health Information Act, the Health Information Protection Act, the Privacy Act. And while these may not apply directly to condo corporations, there's a reason for that. Because condo corps are not in the business of gathering and holding and treating and saving medical information. But if all the other health providers are subjected to such stringent regulation, on what basis do we think that the condo corporation would be able to just go and say, you know what, it's David in unit 306, and in fact, this is where he caught it, and these are the symptoms? You can't say that. You can't do that. Now, some people have asked me, well, what about PIPEDA? What about this legislation? Because PIPEDA has a section 7.3, which specifically provides that you can disclose personal information without the consent of the individual of whom the information is about. And you can disclose that in extreme cases, for instance, of emergency or where there's a threat to someone's life or health or security. And so what we've heard was, well, what about that? Can we rely on this? Well, in our view, PIPEDA actually does not apply to condominium corporation. And in our view, it doesn't for the following two reasons. One of them is that a condo corp is not in the course of providing a commercial activity. They're not, in fact, when you look at PIPEDA, it applies to private sector organizations that collect information in the course of a commercial activity. And a commercial activity is meant to include a transaction that is of a commercial nature. We're not in that business. More importantly, Section 55 of the Condo Act provides for a specific exception. Owners are not entitled to access records or information pertaining to a specific unit or a specific owner. So in our view, you can't go around and disclose information. And in fact, it would probably not add much to the equation. What is it to you if it's unit 306 as opposed to unit 509, right? Everybody should be careful with how they interact with people, but I do think that we have an obligation to at least disclose the fact that there's a known case, simply for people to heighten their precautions and their level of carefulness. I don't know, Denise, if you want to add anything to that, or?
No, the only thing is that sometimes, I mean, what we're asking, if that particular resident wants to agree to have their name be revealed to other residents, and that's really for the purposes of assisting them, but for no other reason. And there are, in the state of Florida, I was dealing with an attorney there. She said that is common. And the residents are saying, yes, I want my name to be disclosed, and they have lots of volunteers that are helping and assisting that resident with deliveries. So that's a reason why they may want their name disclosed.
Right, and obviously consent would trump everything I've said now. I mean, obviously if the owner consents to the information being provided, by all means, then you know, document that and you have a bit of a carte blanche. Very quickly, Catherine, you wanted to add something, but very quickly, we're running out of time.
I promise very quickly. I see a lot in the chat of people affirming there have been no positive cases in their condominium corporation. I can't stress this enough. I don't have reason to believe that public health is getting in touch with condominium management firms. As a matter of fact, I don't understand, and Graham, I think, can speak to legally whether or not we're somebody who gets that information. And I don't want people to have a false sense of security because they haven't seen a notice that says we have a positive case in the building. I again go back to saying that you would be better served by assuming the last person who touched anything was COVID positive today.
Okay, so unfortunately my survey didn't really work, and I apologize for that, but you'll be reassured that the panelists are seeing it, and so Graham is confirming that he doesn't have a confirmed case in his tower. That's the only person that was able to answer the question. Sorry about that, we'll work on this next time. Let's talk about.
At least everyone can sleep soundly knowing that that I'm okay for now.
That's right. You're good to go. Change of topic very quickly. What about meetings that can't wait? And that's a question that we just keep getting over and over and over again. And I'm gonna mainly ask Denise to help us with this.
Yes.
How do we deal with that? And I'm gonna go ahead. Go ahead.
Well, did you want to say something, Rod? Go ahead.
Well, I was just going to set the table because I'm going to say this, is that we hear a lot of people who have discovered webinars and they're thinking that this is probably the solution to every problem that has ever existed. But I mean, holding these webinars or these online meetings, there's a lot more to it than that. And there's all sorts of questions, some technical questions for sure. Are you able to figure out how to poll people? Clearly, I'm not. So there's a question of technical savviness, I guess. There's also all sorts of legal questions raised. can we hold meetings by webinar remotely? How do people vote, and so on and so forth? And there's all sorts of logistical issues. How do you control the discussion? How do we allow people to speak and to be heard? How do you know who's participating? How do you deal with registration? So there it is.
Yeah, I know, Rob, because I have I've spoken to a client that's proceeding with one, and I had to caution them as to how to structure it, because right now our legislation does not permit online meetings. It does permit electronic voting. They're very different processes. One is having your meeting like this, like a webinar, and the other is voting electronically, which is a secure way of voting. It ensures that the vote is secret. You can't do that via chats like you see here where everybody can see it. So it's not permitted yet. It may be, and hopefully it will be. Once it is permitted though, you're right. There's all kinds of rules that have to be developed. How do you set up scrutineers? And how do you do an online meeting with electronic voting? So I think that the process is being started now. People are looking at how it will work. But right now, if you're going to do an online webinar or a meeting, it is not an official meeting. So you could still do a proxy, you could still do electronic voting, and your online webinar would be more for information purposes. There are ways to structure a proxy or electronic vote now. But what we're recommending is let's just wait. You could wait at least a couple months unless you've lost the quorum of the board or there's a reason why you need to hold a meeting. Just hold off for now. There won't be any penalties. You've got good reason to delay your AGM.
Right. And so I think one of the questions, as you just said, Denise, would be, is the meeting really required, and is it required now? And if the board has lost quorum, that's an important one. But I would say this is, if you are going to hold a meeting or a webinar, there's various ways of doing that. Can you do it by proxy? Can you do it with a proxy and having in parallel this webinar? And I would urge you to consider, if you're going to hold a meeting, to stick to non-contentious meeting if at all possible, and to stick maybe to a one-item agenda or a two-item agenda, certainly until people get more comfortable with how these work and whether corporations can proceed that way. Did you speak about bylaws, Denise? Required for electronic voting? Did you touch upon that?
Yeah, so right now, under the Condominium Act, in order to do electronic voting, and it talks about electronic voting, that you need a bylaw, although the Condo Authority now has information on the website, which seems to indicate that their interpretation is that you could do a bylaw that will also allow online meetings. So if you have a bylaw, and those are these easy to pass bylaws, so it only requires a majority at a meeting. So once you get a meeting, if you can get a meeting, eventually you will, it's probably best to pass these bylaws, and then you could do both electronic voting and possibly online voting.
Okay. And somebody on the chat line is asking, what about condo board meetings? And can these be held, and how so? Do you want to touch upon that?
Yeah, so right now you can hold your board meetings by teleconference. I mean, the Condominium Act says that all directors have to consent, but I think that the position now is, because of the health and safety concerns, that board meetings can take place by teleconference or webinars.
Right. And so technically consent is required from everybody. And I would say this, if a director was not to consent, I would wonder whether that director, unless there's a good reason, I would wonder whether that director is meeting his or her obligations under the Act to act diligently and honestly and in good faith, right? Unless there's a good reason for not holding it. So we're sort of running out of time, and we're at the end of the presentation. I think we've covered pretty much everything that we had on the agenda. As I said, we had hundreds of questions, and we can't answer them all. And we've done our best to sort of gather together the ones that were like more common. But the good news is that we'll be back here next week, same time, same channel, same people, same characters. And so we'll have more questions and more time to cover more topics. So for instance, what we had to skip this time around is what to do with the April arrears. You got time. If somebody fell into arrears just this April 1st, we got time, so don't worry about it. And I'd also like to focus on certain elements of security and safety and use maybe more of Jason's time next time around. But as we've gotten to the habit, what I'd like to do with the couple of seconds that we have left is I'm going to go around the table and ask whether anybody has a topic or a point that they want to make before we let them go. And it'll be my chance also to thank them for their participation. So I'm going to start with you, Sandy Folds from Wilson Blanchard Management. With words of
Sure.
wisdom.
Yep. Everyone just needs to stay home unless you're an essential service. Limit your visits to the store for supplies. Continue to practice social distancing and stay healthy.
Right, thank you. And you see that I'm sort of skipping the various slides. The slides will be up on the Condo Advisor blog. You'll be able to download them, but they're basically the points that we've covered already today. And so that's why you're not seeing them. Next person on my list, Catherine Gao, speaking on behalf of ACMO. Words of wisdom?
One of my favorite resources has recently been Rick Mercer's rant on not looking for loopholes. So if you have the opportunity, perhaps see that, perhaps share that, particularly if you have folks who seem to be looking for loopholes. As always, keep calm, wash your hands, sanitize your cell phone, and hexamea to anybody who will be celebrating tomorrow evening.
Right. And on the topic of people looking for loopholes, I mean, they ran out of words. They ran out of ways of telling us to stay home. I mean, Nova Scotia became very creative, telling people to say the blaze is home. And so that's sort of, I think, the message out there. Denise Lash for CAI and from Lash Condo Law, parting
Well,
words?
this is all new to all of us. And I think that what we need to do is use our best judgment. There's no clear right answer, but we've got to act reasonably and use a common sense approach and, really don't take on the role of a health provider.
Stay in your lane, Denise, right?
I wasn't going to say it again, but exactly.
It's your sign off now.
Right. Graham McPherson, Gowling WLG.
Yeah, so thank you to everybody who came in today. And I guess my 2 cents would be, I know how difficult this is and we're all still adjusting to it, but, we are all in this together alone here. So just remember that we're all going through the same thing. And as long as we all stay strong and count on one another like we have been, we'll get this resolved as quickly as it can be.
Wonderful. David Plotkin, Gowling WLG. Words of wisdom?
And on the same point that as Graham, a happy and healthy Passover to everyone celebrating and Easter thereafter. I know it'll be difficult for a lot of us celebrating this with our families via Zoom or other electronic means. But as all of our community leaders are suggesting and our health providers are definitely directing, we thank you all for participating via electronic means and helping to flatten the curve by not having these large family gatherings as all of us are used to having.
Thank you, David. Jason Reed from the National Life Safety Group, parting words?
Yeah, I wish everybody a wonderful holiday weekend and holiday this week. I can't stress enough, document what you've done this week. That's critical. If you've enhanced cleaning this week and you're wiping down those elevator buttons on all 27 floors of your high rise, document the date and times you're doing this. You will need to review this documentation 6 to 12 months down the road. Make it easy for yourself.
Thank you so very much, David. And so everybody, before I sign off, again, a reminder, we will meet next week, same time, so Tuesday, because it's still the Holy Week for many of us. And so we're trying to find the day where it's going to be the least disruptive. So we went for Tuesday, April 14th at 5 p.m. You'll need to register again. You can register to our webinars by clicking the webinar tab on Condo Advisor. You'll get to see next week's topics. You'll get to see the registration form because you need to register. That way you get an email telling you how to log in. And it'll also invite you to provide us with questions if you have any questions or topics you'd like us to cover. And under this tab, the webinar tab, if you scroll down, you'll get to see past webinars. And slowly but surely, we're uploading the recordings, we're uploading the PowerPoint presentations, and so on and so forth. So there it is. It's 6:15 almost, and we thank you very much for having taken the time to join us to discuss these important topics. You're truly leaders in your communities, and people are relying on you to help them navigate through these difficult moments. Wishing everybody a good Holy Weeks, a good Passover, happy Easter for those celebrating it, and happy weekends for everybody. Thank you very much. Have a great evening.